The Department of the Treasury Financial Crimes Enforcement Network demonstrates the roles in a report for shell companies in the financial crimes money laundering schemes. This is specifically targeting limited liability companies, but it applies to different types of companies as stated here. The focus of the paper is on limited liability companies, but other business entities, including trusts, business trusts, and corporations, are vulnerable to abuse. The key findings demonstrate that these companies use these separate subsidiaries for illicit activities, and they must continually be monitored because they use them as vehicles for financial crime schemes, including the use of them for fraudulent loans. There's a major movement of billions and billions, trillions, to be more accurate, of dollars that are being illicitly laundered through terrorist financing. So they use these entities to facilitate the conversion of United States dollars, signature dollars in United States currency, for the laundering to use for terrorist financing, to terrorize civilians upon the Americas, North America, and the several states of the American Union. These companies utilize these shell companies for both domestic and international. Now, most don't recognize or realize that domestic specifically only encompasses United States, but international is where you speak intrastate and the several states of the American Union, where 15 U.S.C. 1, restraint of trade against the civilians from the several states, occurs on a daily basis. The formation of these companies ensures that these entities are impersonating the original issuers, and they're acting in roles pretending to buy and sell when they don't have the right. This is in violation of state laws that they're operating in. An excellent example of this is the big countrywide scandal that occurred a few years ago, where California was the lead, supposedly, in combating the fraud, and the funds that they found were illicitly taken from the issuers were taken by the state. The governor took those funds, and those who committed those crimes continue to this day to foreclose on those issuers without any intervention from any regulatory entities that have the inside track and knowledge of the criminal activities that has taken place to date. Beneficial ownership fraud is a huge problem. The companies are using the Securities and Exchange Commission, and they use FINRA as a legal fence, a fence to protect their illicit criminal activity. Now, specifically, they are taking signature dollars in United States currency and reducing them to Federal Reserve notes. The states, such as California, have institutionalized laws to allow that in order for them to escheat the employee securities companies of all funds and turn around and force the payment of the installments that were illicitly and illegally created from the par value credits. And now we have debt peonage, human trafficking, and debt slavery that is taking place by these companies who have taken advantage of the lack of regulatory oversight and lack of intervention by Congress. FinCEN has taken initiatives that have not dealt effectively with these issues. They have these criminal organizations that continue to set up these shell companies. So with what we noted in the mortgage fraud scandals, the companies that committed the crimes disappeared. Well, now, about 10 years later, start going back and checking the state registries and the fictitious business registrations, and you will find that they have now, not only have they come back, but they've come back in those same names, and most of them in the same city that they initially conducted these illicit and illegal activities: beneficial ownership fraud, wire transfer fraud, and title insurance fraud.